Sir, you're charged with interference with the duties of a public.
Okay, pause. Right out of the gate, this defendant is hit with a serious charge, interfering with a public servant. In Texas, that can mean anything from blocking an officer to refusing lawful commands. And yes, 6 months in jail or a $2,000 fine is on the table. Question for you: do you think people underestimate how quickly ignoring police commands can escalate into criminal charges?
Servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, sir.
On March 28, 2025, an officer was in the process of serving a capital murder warrant on a suspect in Harris County, Texas. While conducting a felony stop, the defendant, who was identified by his Texas ID card, pulled up on the officer's perimeter, got out of their motor vehicle, and began walking to the residence where the murder suspect was. The officer's supervisor ordered the defendant to stop and stay right there. The defendant refused and continued to ignore officers while walking towards the residence. The officer's supervisor ordered the defendant to step back multiple times and then grabbed the defendant and took him to the ground.
Him?
Yes, Your Honor.
Was he the capital murder suspect?
No, Your Honor.
I live there.
Stop.
Oh, sorry, sir.
I believe that they were in the process of serving a warrant on someone else at the residence, and that's when they came in contact with the defendant. Ordered him to stop. He refused to stop going towards the residence. Your Honor.
Serve the warrant. What ended up happening?
Looks like after refusing commands, there was a brief struggle where he was detained.
Was the murder suspect there?
I'm not sure, Your Honor. It does not say. I have no further facts that show if the warrant was service was complete on the warrant or not, Your Honor, or completed at the time. I just believe they were in the process and believed him to be at the residence, and that's when this incident occurred.
Read it again, if you don't mind.
Yes, Your Honor. On March 28, 2025, the law enforcement officer and Squad 5 of the Houston Police Department's Gang Division served a capital murder warrant for a suspect observed inside a truck at a nearby residence. While conducting a felony stop, the defendant, who is identified by his Texas ID card, pulled up on the perimeter, got out of the vehicle, walked to the sidewalk, and began walking to the residence where the murder suspect was. The supervisor then ordered the defendant to stop and to stay right there. The defendant refused and continued ignoring officers and walking towards the residence. The supervisor ordered him to step back multiple times, but the defendant was once again ignored the officers. The law enforcement officer grabbed the defendant and made him bounce and the ground.
Okay, so now, but when you first started, you said they were going to a capital murder suspect in a car.
Yes, Your Honor. That's what. So I was originally reading the summary, and I'm going straight from the gems now, Your Honor. It looks like the suspect was observed inside a truck at a nearby residence.
So the suspect is not even in the residence.
And there it is, no probable cause. That means the judge isn't convinced the state has enough evidence to even move this case forward. Translation: the charges basically collapse, at least for now. But notice the warning judges often remind defendants that even if they win in court, arguing with law enforcement on the street rarely ends well. What do you think? Is the judge being fair, or is this more of a lesson learned moment?
No.
Then they later state that that the suspect, that the defendant here was walking towards the residence where the murder suspect was. I'm not sure, Your Honor. I have nothing for that.
I find no probable cause in your case. Just be careful, man.
Sir.
When you get into a pissing match with
I understand.
who's going to win?
They are. I understand.
No.
Yes, sir.
All right. Hand,
All right. Did that?
please. You are on bond for an assault in this case, and you've now picked up a new case. What happened to the violation of protective order, please?
Yes, Your Honor. On March 18, 2025, Harris County, Texas, the officer met with Clay Mendes for a BPO call for service. The officer met with Clay as we filed with the defense, sent her threatening text messages and called her 21 times. Claim received calls for 1 day after the 61-day protective order expired. The defendant has a no contact order in place out of Court 5.
You don't get it. You don't get it. I only have one thing to do. I'm sorry, I'm revoking your bond, putting you in jail. I ordered you not to do something, and you're doing whatever you want to do. Doesn't work like that. There are serious consequences. Goes with you. This is Montes.
Did you want another motion?
Yeah.
Okay.
Yeah. Oh, I'm putting a new MOA on him, and I'm gonna advise him that if he violates it again, we'll have a hearing to hold him at no bond, okay? Because the second one, I can have a hearing. I will only touch the assault case, and I'm gonna put it at 5,001. He is made bond on the VPO.
He was doing PR.
They gave him a PR bond on the VPO. It's like, I don't know if I'm gonna keep the PR bond on the VPO as well. Ms. McBroom. Just,
Well, Judge, there were multiple orders in this case for bond conditions, and the one that ordered no contact was not labeled an order in the computer, so I didn't see it. There was another one that was no threatening or harassing, and a third one, and that was blank, and all it said was all conditions to be supervised by the department.
That means they're following the conditions in the state's motion filed on that same day.
say it again.
Oh.
That
right.
order will mean that they're supposed to be following the conditions in the state's motion that are filed on the same day as that transfer order.
Tell him ad nauseum, you know. I'll leave the VPO as is, okay?
Yeah.
I'm putting a new protective order in today, and I'll advise him that he's not to have contact with this person. And if he does again, I'll have a hearing to hold him at no bond. Okay? So yeah, the VPO, he's made bond 2,500, and I'm gonna, at the assault, I'm putting it at 5,001. Okay?
Thank you, Judge.
Thanks. Morning, Mr. Jordan. So you're charged with interference in the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 27, 2025, an officer was working a second job at Dick's Sporting Goods in Harris County, Texas, and was approached by the store manager, the witness. This advised the officer that the defendant walked into the store with another individual, and the witness advised the officer the other individual with the defendant walked out of the store without paying for any merchandise. The complaining witness stated he wanted the defendant to trespass because the defendant was seen on camera attempting to cover the individual while the individual was stealing merchandise. The officer stopped the defendant at the front entrance of the store, and the officer stated the defendant would be trespassing the store. The defendant became irate and more aggressive. The officer ordered the defendant to place his hands behind his back and placed handcuffs on the defendant's right wrist. The defendant twisted his body and tensed his muscles. The defendant, with great amount of force, threw his left arm forward and threw his left arm backwards towards the officer. The officer attempted to gain control of the defendant's left arm. The defendant began pulling away, and the officer had grabbed the defendant's body with both arms and guide the defendant toward a rack where the officer was able to excuse me, Your Honor, tongue twister, where they were able to detain the defendant. The defendant was identified by his Texas driver's license.
What's he under arrest for?
I believe he was under arrest for trespass originally, Your Honor.
Oh.
We have,
You gotta,
yes, Your Honor. We just have a brief moment.
are you losing? Are you losing?
Your Honor, the only thing I have is that the suspect began acting irate and clearly becoming more aggressive. And then the officer went to detain the suspect by grabbing his right wrist.
No. All right. When you get into a pissing match with the people who have the power of arrest, who's going to win every single time? You know what I mean? Every single time. Sometimes it's better to tuck your tail at times because you may end up winning in the long run. I'm going to find no probable cause in the case. Just be careful, man. I probably wouldn't go back to the sticks because it's not going to go well. You know what I mean? All right, hang tight.
I am here on Destiny Drake Osby. Yesterday, you ordered that she appear today. I was appointed last Friday. She caught a new ag assault family member in another court.
Now,
She is in court eight's holdover right now.
do you mind bringing up, please?
Last name is Drake-Osby. The case before you, like I said, it was recently appointed a week ago today. It looks like the arrest was the following day, whatever this new thing is.
This is for the,
Well, no, the new law violation that she caught in felony
let's,
court.
hold on before, because I want her to hear everything.
Gotcha.
I mean, Sean. On bond for DWI with us, and you've now picked up an aggravated assault of a family member. You might dismiss Drake Osby. What happened in the ag assault, please?
Yes, Your Honor. On April 1st, 2020. As first specified, the plaintiff and the defendant are exes from a prior dating relationship. On April 1st, 2025, an officer was dispatched to an address in Houston County, Texas, responsible for disturbance call. The complainant stated there was verbal altercation when the defendant took the complainant's cell phone. The defendant then entered the bedroom and began striking, phone and objects to break it. The complainant was able to retrieve his cell phone.
While bond revoked. This means the defendant goes straight back to jail, no chance of release unless a new bond is set. And all of this started over a phone argument. This is where legal drama meets personal choices, one bad decision spirals into felony assault and a $50,000 bond. Let me ask, do you think the system is too harsh here, or was the judge left with no choice given the violence?
Time the defendant began to strike the complainant in the head and torso with a close fist, causing him to fall on the ground. The complainant was able to walk away, and the defendant grabbed a metal object and struck the complainant in the head and arm, causing 2 lacerations on his left eye and a laceration on his right eye, and multiple scratches on both arms. The defendant then jumped a fence and fled the scene. The object was a solid metal bracket, 12 to 16 inches in width, made of heavy gauge steel designed to hold 2 cylindrical metal tubes and has multiple sharp triggers. The item is manufactured for law enforcement officer use as a mounting or deployment device for entire deflation.
And all this over a phone? Ms. Drake Osby, I now have to revoke your bond in our case as well. I'm sorry, so I'm gonna set it at 5,001. You've still not made bond on the felony case, so if you do, I mean, we can talk, but John, I think he's set for when? She's set for,
514, Your Honor. Yes, sir.
okay, do you want to do, I guess, the day after then?
You look at one other thing, Judge.
Well, I think the felony is actually set for Monday. Our case before this one was caught up was when she was reset for 514.
It's up to, I'm good with whatever you want to.
I'm actually looking, I don't have any new discovery to look over because this case is so new. There weren't even any body cams for me, so I'm pretty much waiting on everything. I'll leave it where it is and I'll monitor things and see what's going on with the felony case, Judge.
Okay. All right. Thanks.
Thank you, Judge.
So I've got a couple to talk to you about.
Okay.
Start with the easier one first.